Yes, Mr. Chant.
My Lord, may we start with the contract, please, in the bundle at tab 21, core bundle 21, starting at the title page of 335, simply to show your lordships that this was a 5-year term. And one can see that from the second box down, commencement date 11th October 2019, expiry just by the first full punch is 31st of December 2024. If I can then take you on to page 343, your lordship sees a section to deal with charges.
Yeah.
And it says that 3 lines down, fixed prices have been agreed for delivery packages as set out in the table below, including optional packages. And over the page, one sees 2 columns. The column on the left is for a hybrid solution. The column on the right was a standalone solution. The hybrid solution was one that would be integrated with BMW. That didn't happen. It's common ground that the standalone solution was contracted for, and your lordships will see that the first total net, including excluding optional, is a fraction over 9 million, 9,050,000 euros. I'll call it 9 million for the sake of convenience. That's the money. If we move on then please to page 346, you see the definition of charges. Charges means the fees, charges, or other amounts that are payable by RRMC to the supplier for the services, with such fees and charges being specified in section 5, and then section 5 charges, or in any purchase order. And we submit that definition is wide. It is apt to include a proportion of the charges. It is apt to include the sums payable under clause 26.1.1 for unavoidable commitments. Now, the reason for taking you there was initially because my learned friend argued in his skeleton that a proportion of charges fell outside the ambit of charges and was therefore not something available against which Rolls-Royce could set off. We submitted in our skeleton that was a bad point. The definition of charges would plainly include a proportion of charges for DPs that had been completed but perhaps hadn't been accepted. DPs where work had been done which had been valued under 26.1.1. There's been a seismic change in the landscape in light of my Lord Justice Phillips's observation to my learned friend with which he assented that charges are not capped. And we respectfully agree. I should point out that in its pleading, the learned friend's reply, which one sees at page 316 of the core bundle behind tab 20, that there was an admission that both parties' claims are capped at the sum of 5 million euros. Now, my learned friend made 2 claims in the particulars of claim. One was a claim for loss of profit for over 6 million, and the other claim was over 2 million under clause 26.1.1 in the alternative. And one can see that, my lord, from tab 18 of the bundle, where loss and damage is claimed on page 204, I beg your pardon, 203, top of the page, 6.4 million is the last figure one sees in the incomplete paragraph above 29.1. It's made up of the sums that are then set out below, but a claim for 6.4 million. then we turn over the page to 31, paragraph 31. Alternatively, if which is denied, the defendant lawfully terminated the agreement pursuant to clause 13.11.3. Clause 26.1.1 is then set out, and we have a table which amounts to, sorry, I said two point something. It was 3.2 million, roughly, for.
I'm really sorry, you've lost. Where are you reading from now?
31.2.
So the claim on the basis that they were entitled to terminate was 6.4 million.
Yes.
If they were wrong about that and your clients were entitled to terminate, then they still had a claim, the value of the services, and that
Yes.
was just under 3.2.
Indeed.
Yeah.
And that's the point. The admission that they make in the reply to which I took you just a moment ago, that the cap applies, obviously doesn't apply to the alternative claim because it's below 5 million.
Yeah.
But they certainly accepted that it applied to the higher claim. Now, of course, this wasn't something that was ventilated in front of the judge below in the pleadings because there was no plea to the effect of the cap and how it should be dealt with. So that was something that was dealt with exclusively in closing submissions which we received on Friday at 5:45 with one working day before the oral closing submissions in reply. And the 10 words that we have. But, sorry, and the Tojo Maru being relied upon. So we'll back to the contract. The proportion of charges argument in Millennium Friends Skeletons fall away. And we're left with the concept that, and the acceptance that charges as defined are not caught by the cap, and in due course you'll see why that makes sense. May I then take you very briefly through clauses I believe you've seen before, but just to show you the complete sequence and the complete range of clauses that are relevant to the construction issues. On page 363, your Lordship has clause 13, which deals with delivery, acceptance and remedies. And reading very quickly, clause 13.1 requires that the supplier should deliver each software module to the site by the applicable software delivery date. Clause 13.10 on page 364, Rolls-Royce may reject any of the deliverables which in its reasonable opinion do not conform with the specification or purchase order or are otherwise incomplete, delivered late or damaged or do not comply with the terms of this agreement. Title to the deliverables passes on payment. Then we have 13.11. If in the reasonable opinion of Rolls-Royce the supplier fails to perform the services in accordance with this agreement or to deliver deliverables by the applicable delivery dates or milestone dates, or if RMC rejects the deliverables without limitation to any other rights or remedies, RMC shall have the following rights. And then at 13.11.3, the right to terminate. 11.5, the right to perform services itself. And then 13.11.8, to hold the supplier accountable for any additional costs, loss or expenses incurred by RMC. Now, in addition to finding that there was repudiatory breach and repudiatory breach damages flowed, the parallel case that was run was that there was a right to contractual loss of bargain damages under these clauses. And indeed, having relied upon clause 13.11 in its defence and counterclaim, the judge found that the termination under clause 13.11 was lawful, in addition to finding that there was a repudiatory breach, and the judge referred then to the rights granted to Rolls-Royce under clause 13.11 when assessing damages. And I don't need to take your lordships to it. I think my learned friend has already taken you there, but it's judgment, paragraphs 328 to 329, behind tab 8, page 154 and 155 of the core bundle. So there were two claims being run: repudiatory breach, loss of bargain damages, contractual termination, giving rise to contractual rights contractual loss of bargain damages. If I can then take you, please, to, on the same page, 364, clause 14.1, 14.3, and 14.5, your Lordship see that under 14.1, Rolls-Royce's obligation is to pay shall pay the charges, with such charges being the only full and fixed remuneration for the supplier for the services. 14.3, supplier shall promptly invoice RMC in accordance with agreed milestones. And then 14.5, Rolls-Royce shall be under no obligation to pay or reimburse any expenses incurred by the supplier unless included in section 5. Those are the obligations which we say are then changed dramatically by 26.1.1, which is why I'll come on to in a moment the construction as we say it is on terms of set off and the cap. Your Lordships have already seen 14.9. No, I don't believe you have. Sorry, 14.9 says this. I'm skipping over 14.8 because I need to come back to it. 14.9 says Rolls-Royce has a right to withhold payment of invoices. Rolls-Royce should be entitled to withhold payment of any charges in whole or in part without breaching this agreement where it determines that there is a dispute regarding the services or deliverables, or if any invoice is inaccurate, Rolls-Royce shall pay the balance of any invoice which is not disputed by RMC. Now again, this to some extent has gone away, but my learned friend was arguing that it was unfair, relying on the laundry example in Lord Denning's judgment in Tojo Maru. It's unfair that a party could manipulate the cap by withholding payment. It's not unfair because this gives us a right to do so in the circumstances set out there. Also, I'll come on to in a moment because there was a right of termination that Topalsson enjoyed if there was persistent failure to pay. But those points go in my submission. We don't need to trouble ourselves with the Tojo Maru because of my learned friend's concession this morning that, or acceptance, put it more neutrally, acceptance this morning, that charges are not within the cap. One doesn't need to worry about anything under 26.1.1 being capped because they're charges, and therefore the laundry example simply doesn't apply.
I don't understand that at all.
I'm very happy to take it again now, or with the Tojo Maru in front of us. But perhaps I could ask your Lordship to elucidate.
In the Tojo Maru, the example, the laundry example, only one side of the transaction is capped, namely the loss of shirts.
Yes.
The charges are not capped.
The charges are not capped.
No. So that doesn't stop the analysis in the Tojo Maru applying to.
I see your Lordship's point. I'm sorry. I took it too quickly. I see your Lordship's point. Can I come back to that? It very much explodes the way in which the cap is said to operate. I can give you the headline now. If charges are not capped, but our claims are capped before set off, then that is a fundamentally unfair proposition. Why? Well, perhaps I can take it in stages. Perhaps I can take your Lordship to the set-off clause first.
Well, as you raised it, I mean, the position is that the likely commercial scenario here is that the claimant will be earning its fees, its charges. Your likely claims are for damages or for termination, possibly the refund of charges. But the big issue here is that your client could well have very large claims for loss of profits, breach of.
They're excluded, I believe.
Or as indeed you had for 8 million. And the question is, when that is capped, do you or do you not can you or can you not take into account the charges that you owe the claimant? That's a simple question.
Yes, and that's dealt with expressly and explicitly by the set-off provision of clause 14.8, which I'll turn to now. So page 365, there are two, paragraph clause 14.8, Rolls-Royce shall be entitled to set off any charges due to the supplier under this agreement. Just pausing there. Any charges as defined is a wide term and apt to include, and does include in our submission, sums payable under clause 26.1.1. And it's now a common ground that the charges are not capped against any amount owed by the supplier to ROMC under the agreement, including any service credits or owed by supplier to any BMW Group company under any other agreement. It's leaving BMW out of it for the moment. In our submission, the natural and ordinary language of the clause is not a reference and does not and cannot refer to capped amounts. It doesn't refer to capped charges. It doesn't refer to capped amounts owed by the supplier to RRMC. And we submit that this is a complete answer to my learned friend's sequencing question or postulation.
Well, forgive me, if you read 14.8, entitled to set off any charges due to the supplier against any amounts owed to RMCC, but the amounts owed to RMCC, it begs the question whether or not that is the capped amount or not.
My lord, in our submission, that question does arise, but the language that is used in our submission suggests that it is not a capped amount.
Well, is that right? Because the clause 20 provides the liability, that is the liability of one party to the other, shall be limited. So how can one say in 14.8 the amount against which you can set off the amount owed by the supplier is more than 5 million, and under 20 it is limited to 5 million? But you want to say that the amount owed by the supplier to RMM can be more than 5 million, because otherwise you couldn't set off against it.
Well, my lord, I think the first proposition is that if the parties had intended to refer to capped amounts, they would have said so, and they don't.
Well, it's not capped amount, it's what the liability is. And the liability the liability simply isn't more than 5 million. So how can you set off against a sum of more than 5 million?
Well, my lord, in order to be able to cap something, you have to ascertain what it is that is being capped, whether it is above or below. And in common parlance, I would submit that you find out what the money owing is, and then you apply the cap, if you are talking about cap liabilities under clause 20. But for the purposes of set-off, there is no reference to capped amounts, and that the ordinary and natural meaning in our submission of the words any amount owed by the supplier to RRMC is not a capped amount, but the gross sum before any set-off is made and before the cap is applied.
Well, may I ask you to address the point of what do you mean by capped amount? The clause doesn't have a concept of a capped amount. What it says is what is the liability. It's headed liability, and
Yes.
There's no concept of a pre-capped and a post-capped amount. There's only what is the liability.
I agree.
And what this clause says is, in no circumstances shall the liability be more than 5 million. So when you come to look at 14.8, the amount owed by the supplier to RMC under this agreement, that cannot be more than 5 million. Can it?
May I get it this way? This was a 5-year contract. Clause 20 is a clause which extends throughout the life of the contract, and it contemplates and encompasses claims that could be made on any number of occasions.
Yes.
Now, I don't want to get into sort of examples because that's not this case, but there is obviously something different going on in clause 20 than ascertaining what happens on claims, for example, between the parties, which would result in a set-off which is below the cap. So clause 20 is dealing with the 5-year term. Clause 14.8 is dealing with a contractual right of set-off, not an equitable right, which obviously we would have as well, but a contractual right of set-off in relation to sums owed. Charges is easy. We're happy that the cap doesn't apply to charges. If the cap doesn't apply to charges, we submit that some sort of clear indication would be needed that sums owed by supplier should be or intended to be capped, and there is absolutely nothing there. And to say that what is owed is coexistent with or consistent with or the same thing as a total liability, my submission that's wrong.
You can't owe something unless it's a liability, can you?
Well, you
There's
can.
no liability.
Yeah, well, that's the point. Before you get to the cap, you have to ascertain what's owed. Otherwise, the cap has nothing to bite on. You have to have a gross figure, and you have to have a gross figure to see whether or not the cap applies. So you work out that gross figure, and if you don't call it the sum owed, I don't know what you do call it.
Well, it's sum owed, but for the limitation on liability.
But that is precisely the point. So in order to work out what is set off, you take the sum owed before any cap is applied, and you set it off against the charges. That is the right. If I may preannate the BMW point, let's say that there was a huge contract that Topalsson had with BMW under which service credits were racked up to the tune of 10 million. On what basis would that be a capped amount? It wouldn't. It's not inside the contract. No cap would apply. It would be a sum owed. And that would be the same in my submission as saying that the sum is owed to Rolls-Royce. So it's when if I can just switch tack for one moment, an equitable defence of set-off is one that was always available. It wasn't needed in this case because we had a contractual right of set-off. But an equitable right of set-off is a defence to a claim. And in my submission, there's no justification for construing this contractual clause in a different way to an equitable set-off. The equitable set-off in my submission would take place when you work out what is owed to Rolls-Royce, you work out what charges are due to Topalsson, you set the two off. And the equitable defence takes place against the claim, Topalsson being the claimant here, against the claim that is being made, and judgment is given for the balance. One then might apply the cap, but it is only after that exercise is carried out.
Take the example we discussed earlier, and you don't want to do examples that aren't this case, but the clause covers all cases. If there was, during the life of the 5 years, some early occasion when a liability accrued from Topalsson to you, or your client, and you at the time had outstanding charges of the same amount, let's say it's £1 million, you have a choice. You could either pay the charges and then recover on under the obligation to pay, or you could offset the two. That's what this clause allows you to do. When you come to the end of the term, does the question whether the cap encompasses or includes, or the question whether the £1 million that was due earlier count towards the cap, depend wholly on whether you chose to set off or pay that earlier amount?
My lord, it might do, and I'm giving a cautious reply because I haven't. It's difficult to envisage what other possibilities there might be. If there was a £1 million liability, so just pausing for a moment, the charges are payable in any event, not capped. If we had a claim for 1 million, which we didn't prosecute at the time, didn't set off against the charges owed, but kept in the back pocket, at the time of the final reckoning on termination for cause, for example, then that claim would be rolled up in it. So it wouldn't apply. It might apply if it was a contractual breach of a provision not giving rise to any rights of termination, or we lost the rights of termination on some such. But it's unlikely to be a claim that has to be dealt with on termination separately, because the overwhelming likelihood in my submission is that it would be rolled up with the loss and damage on termination.
Right, but my question is whether you've got a choice at the time to accept payment from Topalsson for the £1 million because it's due and payable, let's say year 2 of the contract when this happens. You could accept payment, or you could offset that amount due to you against your obligation to pay charges until it's satisfied. If they pay you for it, then is that £1 million part of the liability which is capped?
If they pay the £1 million, it would be arguable that it would reduce the cap to 4 million.
Why only arguable?
Because, well, I'm being cautious, but it seems to me that it rather depends on when. So if it was actually paid as a liability for breach of contract, it probably would go towards reducing the cap, yes.
Yeah. So the question whether it goes to reducing the cap depends on the circumstance of whether or not you accepted payment or required payment, or discharged the payment due to you by offsetting it against your liability under a charge.
Yeah. I'm still cautious because it may well be the case that Topalsson would argue a different point. It could argue, we could argue, I suppose, that we had the right to set off, but we didn't, and that it doesn't fall within the cap. But I think that would be a difficult argument. I was always a little wary of questions from the bench to see where they're going. So, just to recap, the beginning and end of this first, the starting point of this first part of the appeal rests on the true construction of clause 14.8. We do also pray in aid. I think I've covered it, but the triple point point, which is always rolled out, I'm afraid, clear words need to be used to exclude or limit a valuable right. And in our submission, if it was intended, or sorry, if it was the case that clause 14.8 applied to only capped amounts, then clear words would have to be used. The normal expectations of commercial parties, we would submit, is that they will be able to set off sums each owes to the other. And if that valuable right is to be restricted, we would submit that clear words are needed. Clause 14.11, 14.12 is interesting. I need to come back to those in the second part of the appeal.
Forgive me, before you go away from 14.8, I'd like to understand how, in terms of the right of set-off, how does whether you've capped the liability or not matter? It doesn't affect your right of set-off, does it?
Sorry, I didn't follow that.
Well, let's say you have a claim for 8 million.
Yes.
How does whether or not you cap that before or after set-off matter to the right to set off?
Well, it has a profound effect. If charges are owed to Coulson of say 5 million, and we're entitled to set off under clause 14.8, as we say we are, the 8 million that your lordship postulated, then the result of that set off is a balance owing to Rolls-Royce of 3 million. The set off doesn't apply. But if the claim that Rolls-Royce has of 8 million is capped before the set-off, it's reduced to 5 million, and the 5 million of charges can then be used by Topalsson on its construction to reduce its liability to zero. And
That I can see it. I can see that it affects the total amount of your claim, the liability. Don't think it affects that set off, though, did it?
I'm sorry, the set-off, as I've submitted, is between amounts that are owed, which are amounts owed before any cap is applied. The set-off takes place before Clause 20 is applied. And that is obviously important because it prevents the obvious unfairness of the example that we've just worked through from occurring. If we have suffered a loss at Topalsson's hands of 8 million euros, but we owe them charges, say under clause 26.1.1 for the sake of example, the commercial businessman would expect to be able to say, well, you owe me 8, I owe you 5 million under 26.1.1, the net result is 3, you pay me 3. But if Topalsson's correct in its construction, our 8 million claim is reduced first of all by the cap to 5, and at that point, on Topalsson's case, their 5 million comes into play and wipes out.
The other way of looking at it is that Topalsson's got a claim, is owed £5 million. You wipe that £5 million out with your 8 million, and are still owed 8 million. So even though
3
million, even though their liability to you is capped at 5 million, they end up owing you 3 million despite having been paid nothing. And
despite us having paid nothing.
Yeah, being paid nothing.
Yes.
And that's the other side of the unfairness, isn't it?
Well, a party that's
because they are contracting to do this work for £9 million.
Yes.
And part of that bargain is the only liability that they will incur to you in carrying out that work is limited to 5 million.
Yes.
But if, on your analysis, in fact, their liability to you could be 14 million, because they could be liable if you suffered 14 million losses and you hadn't paid them a penny of the 9 million, they could find themselves 9 million wiped out and owing you another 5 million.
Well,
that's theoretically possible, isn't it?
Again, these are the theories, and as I've indicated earlier, if we could look at what's the position on contractual termination, which is the position here, in my submission, that's far more illuminating than these postulations, because one always looks at scenarios to see if one can break the logic of the argument before it.
But forgive me, the example I give you is not an extreme. It is the contractual bargain. We will be paid 5 million, so 9 million, and as part of that bargain, any claim that Rolls-Royce might have for poor performance or breach is limited to 5 million.
Yes, and one can see that if it was 9 million out of 9,050,000, and that work had been delivered and money was due and payable for the charges in accordance with the scheme that I've taken your lordships to, and there was termination at that stage, the contract and the project would be all but complete. So the chances in those circumstances of Rolls-Royce having a substantial claim to complete the services under the contract, or there being repudiatory breach, indeed, would be very slim. So again, one takes an example and bandies figures about, but they are figures that don't, in my submission, bear any real resemblance to what was likely to have eventuated. Those are theoreticals. What we have is the actual, which the judge dealt with, and that was, in my submission, something that clearly shows where the merits of the arguments lie. I said I'd come back to interest in due course. I will. If I can go, please, to page 370, the liability clause that your lordships have seen. We have the following submissions on the language. Firstly, that the phrase "the aggregate of all claims" is apt to include claims, cross-claims and counterclaims, i.e. claims going both ways. And that must include the claim of set-off. And it obviously includes money owed by Topalsson to BMW if there is any. Secondly, we say that the total liability is arrived at by reference to all of those claims, cross-claims and counterclaims. And it is the end point after all claims, cross-claims, etc. have been accounted for. And obviously one has the 5-year period, so it is a clause which extends over that period where there may be many claims and cross-claims. But the end result is who has what liability when all is said and done and the contract is complete. May I make this general observation?
Because nobody's really focused on this, but every time I look at this clause, one of the things I stub my toe on is the total liability of either party to the other. So you're looking at the liability of either party to the other.
Yes.
So you look at the liability of A to B and B to A.
Yes, but I agree with that, but it doesn't say when you look at it. And the submissions I've just made in my submission elucidate that. It's at the end point. It's when all is said and done. It's the end of the contract. So one has this 5-year period rolling along where the parties, where it's contemplated that there'll be claims and cross-claims, there'll be defences of set-off, claims for set-off, and that at the end of that period, when the contract expires or is terminated, the day of reckoning comes and one works out who owes what to whom. And that liability, one way or another, cannot exceed 5 million euros. We would make these observations, my lord. Firstly, here we have a single cap, which is applied to both parties. In many contracts, you find that the liability cap is calculated separately for each party. But that's not the case here. It is a single cap. Secondly, that you have a clause 20, which is dealing with the allocation of risk, which we all agreed about. And in our submission, the risk that the parties have agreed upon is that the other should not, one should not be liable to the other when all is said and done for more than this figure. Insofar as I need to repeat myself, I don't accept the premise that there is anything in clause 20 which suggests that the cap is applied before Rolls-Royce's rights of set-off or Topalsson's rights of set-off are applied. There's nothing there, it's completely silent, unlike clause 14.8. And in my submission, if there was the intention that this clause should apply to each party's claims separately before they're set off, that again would be a serious and significant curtailment of each party's rights, requiring clear words. But there's nothing in clause 20 which indicates that that is what is intended. So the 5-year term, claims, cross-claims going each way, rights of set-off being exercised in relation to a claim for breach, for example. At the end of the day, it's 5 million euros. Who owes what to whom? and that is the allocation of risk that the parties agreed upon, having agreed that they should have a contractual right to set off in the terms already explained. May I then go on to the termination rights that one finds at clause 25. Your Lordship sees that under 25.1 there is a right of termination for convenience.
Well, the judge has dealt with this, hasn't she? And it's not part of the appeal. That
No, it's not part of the appeal, but
it was terminated as a result of effectively breach.
yes, but my Lord, in order to understand what's going on under 26.1.1 and 26.2 and why that is a composite exercise, I'm just showing your Lordship the other types of termination that there are, where clause 26.1.1 also applies. So it applies for termination convenience, it applies under 25.3 on written notice for material and persistent breach and fraud, etc. of personnel. 25.4.4, non-material breach of a contract with BMW, and 25.4.7, breach of warranty, standard of quality and fitness, and so on. And then the clause I reverted to before at 25.5.1, your Lordship sees that Topalsson is provided with a right of termination for persistent non-payment. And then we get on to clause 26, the opening words of which say, upon termination of this agreement by RRMC for any reason. So it applies when there is termination for convenience, it applies when there is termination for cause, and it applies where there is termination by Topalsson for persistent non-payment. And then we get to 26.1.1, where it says RRMC's sole liability upon termination of this agreement by RRMC for any reason. RRMC's sole remedy shall be to pay the supplier the proportion of the charges applicable to the services carried out prior to termination and any outstanding unavoidable commitments necessary and solely incurred, etc. We say that those are charges, whether irrespective of the fact they're a proportion of the charges, and obviously the unavoidable commitments are part of the contract price in the sense that that was money Topalsson had to spend to perform the services. 26.1.2 is a carve-out, needn't trouble you with that. And then 26.1.3 says this, RRMC's total liability under clause, that should be 26.1.1, shall not in any circumstances exceed the charges that would have been payable for RRMC to complete the services if the agreement had not been terminated. So the effective cap that is applied there is the 9 million euros that we saw earlier. So that is one half of the equation that occurs when RRMC terminates the agreement for whatever reason. And the point that we make in the skeleton I'll deal with very briefly is that this is a deviation from the contractual terms that were agreed around payment of charges against payment milestones for completed fixed price delivery packages, where no work in progress was payable. Here, there is effectively a contractual right to a quantum merit, where Topalsson is entitled, we say generously, to evaluation of the work that it has done, whether or not a DP is completed or not.
But that would be the position under common law. If you terminate a contractor's contract, the contractor is entitled to credit for the value of the work they've done in general terms.
In general terms, but not under this contract. This was payment for fixed prices for delivery packages.
Yeah, no, I understand that, but I mean, I understand why you say it's therefore different to the norm in the sense that the norm is you only pay on completion of the package. I mean, it's not radical. You said it was generous.
Well, yes. The reason for making the point, my lord, is to counter my learned friend's proposition, which was that the rights gained on termination were very much in our favour, and we say that is not so by reference to the points I've just made.
Okay.
We say it's the other way round. So there's a significant alteration and improvement of Topalsson's rights of payment on termination than under the contract when it was on foot. And that means the right to reject incomplete packages under clause 13.10 does not apply. The right to withhold payment under clause 14.9 does not apply. As I said, and the clause says, we're liable for unavoidable commitments, and such terms fall, or such charges fall within the definition of that word. We then go, please, again on page 374 to clause 26.2, which applies in three circumstances. It says this: upon termination of this agreement by Rolls-Royce under three clauses, Rolls-Royce shall, without limitation to any other of its rights, have the right to recover from the supplier any additional cost of having the services completed by a third party. Now, we didn't rely upon this for termination in our termination notice that was upheld, and we didn't plead any reliance upon it. We pleaded clause 13.11, which, as I've indicated, was a clause the judge upheld in terms of termination and additional cost and expense, which we say is the same as the loss of bargain damages. But here, the additional cost of having the services completed by a third party, in my submission, is another example of the contractual loss of bargain damages right. And the three, just for your sake of completeness, again, all of the clauses, I'm afraid, are wrong in terms of their numbers. It's 25.3.1, 25.4.3, and 25.4.4. 25.3.1 is material breach. 25.4.3 is where Topalsson's personnel are guilty of fraud or dishonesty, and 25.4.7 is breach of warranty. The circumstances that one sees set out in clause 26.2 is the other side of the coin to 26.1. And in our submission, in the analysis that the judge carried out in relation to clause 13.11, there's absolutely no difference between the 13.11 approach and the approach under 26.2 had it been engaged. There's no difference in principle between what's going on in 13.11 as opposed to what's going on in 26.2, except 26.2 only arises in the three circumstances that four circumstances which I've indicated. So the question then arises as to whether or not the rights given to Rolls-Royce under clause 26.2 are rights which, and sums which it can set off under clause 14.8 against sums payable to Topalsson under 26.1. Now, in our submission, the juxtaposition of these two clauses, the fact that they are dealing with what happens on termination, no different from clause 13.11, compels one to the conclusion that a right of set-off under 14.8 arises when one is establishing what is payable to whom. The charge is under 26.1, that's the first limit of clause 14.8, and the additional costs of having the services completed are under 26.2. In our submission, there is complete commercial sense in permitting the parties to set off under clause 14.8 one sum against the other. And we say it's wholly artificial to say that one caps 26.1, first of all, and that's, sorry, I beg your pardon, that's no longer pursued. That's no longer pursued. We say it's totally artificial for 26.1 to, for example, let's say it was 6 million, capped at 5. Sorry, not capped at 5, let's say it's 6 million. And let's say 26.2 was 8 million. We say there's absolutely no commercial sense in saying that we have to pay the 6 million under 26.1 and we only get 5 million back under 26.2. We say that's not how it works. You apply the cap after you've set off, because that is in the language of the clause, the total liability of either party to the other under this agreement in aggregate for all claims, no matter how arising. Turning to the net loss principle, the judge found, and we agree, that a single accounting exercise under the agreement is reflected in the net loss principle in assessing damages. So there is a consistency with the submissions I've made about the way in which the contract works with the position that pertains on ascertaining damages for repudiatory breach on a net loss principle. That was in the judgment at paragraphs 327 to 328, which is made page 154 of the call bundle behind tab 8. Your Lordships will see in our skeleton that we refer to Stanford International Bank and HSBC Bank. Perhaps I could take you there very quickly. It's in the authority bundle at 12, tab 12. Page 385, paragraph 55. SIB's arguments is thus flawed, bottom of page 385, because it disregards the net loss rule. This is the basic rule that applies in awarding damages for breach of contract, or in tort, that losses and gains arising from the breach must be netted off against each other, and only any net loss awarded as damages. And then reference is made and reliance is based upon the well-known case of British Westinghouse. And if one picks up the quote in Lord, if one then goes down to C, one C is a good example in the Hodgson and Trap, although it's a tort claim, we say that doesn't make any difference, where he says, my lords, it cannot be emphasised too often when considering the assessment of damages for negligence, they are intended to be purely compensatory, where the damages claimed are essentially financial in character. The basic rule is that it is the net consequential loss and expense which the court must measure. I don't believe there's any difficulty in that proposition, but we say it is mirrored in the way in which this contract works, that the judge correctly held. Because under 26.1.1, it is implicit in the judge's valuation of the claims that were made in paragraph 31 of the particulars of claim that there was value in the work that the appellant Topalsson had carried out. So in assessing our loss of bargain damages for repudiatory breach, the starting point, as we have laid out in Appendix 1 to the Defence and Counterclaim, which is at the very last document or penultimate document in the supplementary bundle, is to take the cost of a replacement system, and I accept what my learned friend said, and of course you've seen the judgment, but the judge wasn't having the primary claim that we put forward as to the cost of the replacement system, but substituted as a proxy the second lowest bid. But we put that in there in our schedule as the alternative basis of assessment. You take I think it was 13 million was the cost of the replacement system in the second lowest tenderer's bid. You subtracted the 9 million under the contract we're discussing today, and that additional cost is the figure which is the net loss position. The judge then added back the clause 26.1 damages and said, out of that figure, a sum has been paid, an invoice has been rendered, but they're all included in the 800,000. So she embarked upon a process establishing the net loss position for common law damages for repudiatory breach. She said that the contractual provisions were the same and reflected that net loss principle. And she came up with one figure, which was then capped. And in our submission, that follows precisely the contract and the rights of set-off and the way in which we construe the set-off provision at 14.8 reflects precisely the net loss principle. Just dealing with, before I get to the Tojo Maru, just dealing with one final point. We submit that Topalsson's approach favours the wrongdoer. And indeed, where Rolls-Royce terminates for Topalsson's breach, given that clause 26.1 applies to termination of the agreement by RRMC for any reason, we say the 5 million total liability is illusory. Assume here, as the judge found, 26.1 is triggered on Topalsson's repudiatory breach, and say, using round figures, that Topalsson caused 10 million of loss to Rolls-Royce, and that the judge found that 1 million was found payable under 26.11 to Topalsson. On Topalsson's construction, if both of those sums, if the sum, the 10 million that Rolls-Royce has suffered by way of loss of damage is capped before the set-off, the 9 million is reduced to 5, the 1 million is set off, and the only amount that Rolls-Royce is able to get is the 4 million. So in those circumstances, it's not a 5 million cap. I'm assuming there are no other claims in the 5-year period, or 3-year period, or 2-year period. But in the sense, in that the only claims that are made are claims that arise on termination, on Topalsson's arithmetic and on its construction, our claim is knocked back to 5. They get the full effect of their 1, and it's a 4 million.
So I'm being dense, I'm sure. Why do they get the full effect of their 1? You said it's capped at 5. They get the full effect of the 1.
And then you set off in their case.
Just take me through those steps again.
So we have a 10 million euro claim. They claim and are successful in claiming 1 million under 26.11. Our 10 million euro claim is capped at 5 on their construction. We then they accept a right of set-off. So the 5 million is balanced against the 1 million, giving 4 million. And in that situation, we don't even get the full benefit of the cap.
So maybe I'm not understanding how the judge calculated the loss here, but that may not be the right question. The question is, how should the loss have been calculated?
I can answer both. But
on termination, you're entitled, basic principle, you're entitled to the difference between the cost of to you of replacing or completing the contract.
Of being put in the position we would have been
So
in.
the
Yes.
cost of completing
Yeah. Under common law.
less the gain, the benefits you've achieved because of termination, which would be the amounts you're now relieved of paying to Topalsson.
We have to take into account the gain. Yes.
Yes, but the amounts that you're relieved of paying is less because of 26.1 than it might otherwise have been, because you've got to pay for incomplete packages, whereas before you wouldn't have had to do so. So that's not part of the deduction, is it? The £1 million that you're going to have to pay under 26.1 is not part of the gain. So that's taken off the gain which you would deduct from your cost of replacement.
We're talking about purely under the contract and where 26.11 works against 13.11 or 26.2.
Yes.
The point that I was at was that it's not a €5 million cap on Topalsson's construction, because 26.11 amounts are always subtracted from the 5 million. So it's not the cap our liability isn't capped at 5 million, it's capped at whatever 5 million less 26.11 amounts turn out to be.
Can I just take your example? You have a claim for 10 million. There's a 1 million under 26.1. So you say our claim is capped at 5, less 1 is 4 million.
That's my learned friend's argument.
That's right. And you say that would be unfair.
Uncommercial.
Because you're not getting the full benefit of the cap. Let's take the same example. 10 million. But instead of 1 million, 1 million due, let's say 2 million due, or 3 million due, or 4 million due, or 5 million due. In each of those situations, on your argument, you get 5 million.
Correct.
So doesn't that show the absurdity of your argument? That although any claim you've got is capped at 5 million, that you get that, you say, no matter even if whether you owe them 1 million, 2 million, 3 million, 4 million, or 5 million. I mean, what sort of cap is that?
Well, we're still capped at 5 million.
Yes, but their fees, which may be up to 5 million, are wiped out.
Well, we've
And you
suffered
still
loss.
get your 5 million.
But we've suffered. They have caused us loss and damage of 10.
Yes, but that's why now you've come exactly to the example I gave you that you didn't like. That we can take this all away, and we can say that you've got a claim of 14 million, and they've got fees of 9 million, and in that situation, you say you've still got a claim for 5 million.
Well, as I said, I don't think that's a realistic.
Well, why is it any less realistic than 10 and 5? I mean, the point
It
is,
may
what
not be, which is
what
why
it
I'm rather
illustrates-
chary of dealing with.
Illustrates is that the contractual bargain here is they are entitled to up to 9 million in charges, and you are entitled to set off claims that you may have against those charges, but it's limited to 5 million.
Well, just if we take
Not
that in
on-
stages,
you can't
the
have-
contractual
you can't-
price was 9 million.
Yes.
The amount that they may or may not be paid under 26.11 is very unlikely to be 9 million. It might be if it was right at the end, as I've said, in which case Rolls-Royce would not have a claim for 16, 15 or 10 million. It would be the cost of completion. So the examples that we're talking about don't bear on reality in my submission. But the fundamental point is that we have terminated for cause, in this case, under loss of damage principles. The normal net loss principle is that our claim is dealt with on a net basis, the net loss principle, and we have to take into account in that calculation, as the judge did, sums payable or an amount reflecting the value of what we received under the contract, which was the 26.11 sum.
What your argument really amounts to is this, and you may well say this, that's absolutely right and fair, is that where your claim is capped is 5 million above whatever happens to be owed to the Topalsson under 26.1.
Not quite, because that's not the language of the clause that
Effect.
limits liability. Well,
effect
with
of the
respect, it's total liability under this agreement, limited in aggregate for all claims, no matter how arising. It's a clause that one has to read with clause 14.8, as I've indicated, and it is a clause that is concerned with what happens at the end of the contract. And we could, as I said, we could produce scenarios which skew the figures either way. I don't believe the figures that I have produced do skew the result. And taking the figures that the judge found, which was 800,000 for the value of that which was delivered, or the work that was done under 26.11, the learned judge took that into account when assessing common law damages for repudiatory breach, and she set off the 800,000 against the sums owed to Rolls-Royce, and that figure was still above the 5 million cap. She then applied the cap. In my submission, that is orthodox, and it's not just reflects what the contract says, but it reflects fundamental fairness. The damage and loss caused to the defendant was over 6 million, and that is what the judge found. Topalsson doesn't have a right to be paid the contract price, which was your lordship's, the point that I was cavilling with your lordship's example. It has a right under 26.11 to be paid for that which is delivered and presumably of value.
Yes, I don't think I was suggesting that they were. I think my point is that the contractual bargain is that in consideration of an agreement to pay 9 million, one of the terms is that any claims for breach or negligence or termination are limited to 5 million. That's the bargain, isn't it?
Well, it's the aggregate of either part. It's the liability of either party after all claims are taken into account. But it's after. And as I said, one looks at it at the end when the contract either is terminated or it comes to an end.
If you take it, if you allow the price or parts of the price to be taken into account in working out that 5 million, then you have perverted the bargain, haven't you?
But one doesn't take into account the price. One takes into account clause 26.1.
On termination.
On termination, I agree, on termination.
Because clause 20 is not limited to termination. I mean, it applies across the board.
It applies
At any
to the
point.
contract at any point, but the ultimate accounting exercise is done when it comes to an end, if there are any claims outstanding.
Now, did you say you were taking us to the Tojo Maru?
I was taking you to the Tojo Maru, and in essence, we submit that the judge was right. My learned friend has made all the points that need to be made about different facts and different circumstances. It's not actually the decision which the appellants rely upon, but it's the example in Tojo Maru from Mr. Ackman, as he then was, about the laundry. And if I can pick that up, page 51 behind tab, it's not, sorry, you don't have tabs, 51 of the bundle. My learned friend said that the facts in the Tojo Maru did not involve multiple caps, but only one cap, and therefore this was on point. But in my submission, the analogy that is given is the rationale that my learned friends relies upon, not the result that actually pertained in that case. And example about the laundry shirts is where there are separate caps for each shirt. So it's the analogy simply doesn't apply, what one can see in a sense that both Mr. Ackner and Lord Denning have latched onto this example in order to prove the case that was being advanced by the Salvills. The fact that, so I'm just checking so the fact that one sees Lord Denning at C, between C and D, saying equity does not in that case require set off of the £3 against the £2, but only the 10 shillings against the £2, shows that we are far from the rights of set off under a contractual clause as it's possible to be. The equity that Lord Denning was referring to is to be found in what comes before this section, which is the analysis to the effect that it is wrong in principle for Salvills to be deprived of their fee if they damage the ship to £250,000 worth. The fee is 125,000 in this case. It is not right that they should be deprived of that fee because they saved the ship, which was worth £1.5 million. After they were negligent, it was worth £250,000 less. But that £250,000 less figure, the 1.25 million, is the basis upon which the salvage fee is calculated. So the salvage fee reduces. Now, that was the finding that the Court of Appeal made. And when Lord Denning is talking about the equity of the situation, in my submission, he has in mind the facts that he's dealing with, and he's using the laundry example to buttress that. But he does so by reference to something which really is not apposite by way of analogy, for the reasons that the learned judge gave, which was that here each shirt has an individual cap of 10 shillings. That is not the case in this contract. The liability cap at clause 20 is for all claims, cross-claims, counterclaims, set-offs, etc. So it really is not analogous, and it doesn't found a principle and cannot found a principle where the court is concerned, as we are here, with a pure matter of contractual construction. So we say there is no principle here, that the example is not apposite, the facts are obviously wholly different, and it can be safely ignored.
Well, is that right? What is really being said here is that where you have an operative limitation, which is clearly intended to apply to a particular loss. Here, a loss of a shirt worth £3, you're only entitled to 10 shillings. In our case, you have a loss which, on your example, is 10 million, is limited to 5 million. And what Lord Denning says is that you should not readily, whether it's by way of equity or by way of the effect of the clause, allow that loss, allow that limitation to be circumvented by the happenstance of set-off.
Yes, but the laundry case has a cap for each shirt, and what was being suggested is that that cap. Sorry,
I don't understand the relevance of it being for each shirt.
Well, only one shirt has been damaged. The cap applies. The 10 shilling cap applies to that shirt. Yeah. What the owners were seeking to do in the Tojo Maru was to say that the whole of the salvage fee of 125,000, which is not subject to any sort of cap, the 125,000 salvage fee should not be given to the Salvills because they caused £250,000 worth of damage to the ship when they tried to salvage it. And they sought to set that off under equity. And the answer, as I've indicated, was Lord Denning saying there is no equity in that proposition because the way in which salvage works is that the salvage fee is paid by reference to the value of the hull that is saved. And if it's damaged in the course of salvage, you reduce the value of the hull. So, as I say, it's a self-serving argument, but it doesn't, it's simply not analogous because here we have one cap for all claims in aggregate and we just don't have lots of shirts in this case. We have contractual provisions, 26.1, where the sums going both ways, 26.1 and 26.2, are all part of the same transaction, if I can put it like that, termination. They arise on the same event. So there's no question of artificial manipulation.
The shirts are all part of one transaction. I panned in 10 shirts and I'm charged for cleaning them, and one of them is damaged. That's, that's all one transaction.
Yes. Well, okay, so let me take that. 10 shirts go into the laundry. You signed and accepted the terms and condition which say for any shirt that is damaged, the limited liability is 5 shillings.
10 shillings, yeah.
Sorry, 10 shillings. One shirt is damaged. You get the limit of liability, you get 10 shillings, and that's the end of the matter. The laundry says, you owe me £3 for the other 10 shirts, and your answer to that is, oh, well, I had a £3 shirt. But that simply doesn't work. That's not the case here.
Seems to me exactly what you're doing.
Well, with the greatest respect, you're not, because this is these are termination rights that is being valued, totally different from a shirt that is damaged. And as 26.11 makes plain, the rights of termination going to both parties arise on termination for Rolls-Royce and money goes both ways. And in order to determine when liability falls after claims and cross claims, etc., one has to set off those sums under 26.11 against 26.2. As I said, there's no difference between that and 13.11, which was the operative clause for our termination. And all of that arrangement and calculation by the judge reflects precisely, we submit, the common law principles of net loss on repudiatory breach.
All right, is there anything else on the first issue?
Nothing on the first issue. The double counting point, very briefly. Malone Friend said it's necessary to unpick what the judge did. In our submission, that's not right. We're not concerned about whether or not there was an error or not. And it really rather depends, as Malone Friend says, on what was in the judge's mind when she came to the figures, and I'm not going to go into that at all. That was simply to point out what we thought and think may have happened. But the point we were making about double counting is that when you have common law net loss damages assessed for repudiatory breach, you take into account the gains and the losses and come up with a net figure. So in this case, the contract cost is deducted, gains have to be brought into account and set off, and you come out at a figure. On Malone and Friend's case, you do that on his, for our damages, but then on his case, you're entitled, which are then capped, and you then subtract, we say for a second time, the 26.11 sum of 800,000. But we say that's already been taken into account by the judge on the net loss principle.
Paragraph 4. Supplemental, further supplemental statement.
Yes.
Yes. Before 1, you say loss of bargain damages include the cost of the replacement system less the charges payable to A. And then you say that those charges payable to A are taken into account again under 3.
Yep.
But under 1, isn't it the charges payable to A, well, the charges would have been payable to A, but of which Rolls-Royce has been relieved from paying to arrive at the net loss?
Relieved in what sense?
Well, in the sense that your benefit, it's the benefit you've obtained by terminating. You no longer need to pay what we're going to have to pay under the contract.
That's why you take the contract price and you usually add back into the equation what sums have been paid. If you're looking to establish additional cost.
Well, as I read this, it's the cost of the replacement, so what it will cost you now to finish the job elsewhere, less the charges you would have had to pay to A, but now not having to pay.
Yes. Well, I think it's slightly different. Where you've got a contract for 9 million euros for a system, and that is not delivered, and let's assume for the moment that it's not delivered at all, and you derive no benefit at all from the work that's done. Your replacement system costs 13 million, your net loss is 4 million. You've subtracted the price of the contract that you first entered
Because
into.
you don't need to pay it now.
Well, that was the price you were going to have to pay in any event.
Yeah.
So you're only entitled to the additional cost over and above that which you contracted for.
Yes.
Yes, I think we're agreed.
That's because you've been relieved of paying the whole 9 million in that example. But if you've paid half of it, you're only being relieved of paying the remaining.
Yes, and if you paid half, then it would be the difference between the contract price and your new system price, and then you would add back the sums that you have paid to the first contractor. Interest within the cap is the next topic, also an issue of construction. Before turning to the relevant clauses, could I take your lordships, please, to my learned friend's skeleton at paragraph 9, which is in the bundle, core bundle at tab 3, page 27. This is where my learned friends set out to categorize the different types of interest. And they say that the law distinguishes between two types: interest claimed outside statute, where interest is claimed as debt or damages, and interest conferred by statute, where interest is awarded by the same statute on debt or damages. And we say that's a simplification. We say that there is an additional categorization, which is what we have here, which is contractual interest ancillary to a principal liability to pay damages, and one which may preclude statutory interest.
Sorry, contractual interest ancillary to
A principal liability to pay damages. So this is, in this case, damages are not claimed, sorry, in this case, interest is not claimed as damages, as was the case in Sempra Metals. As your lordships know, that was a claim for restitution in respect of advance payments of tax wrongly demanded, and its claim for damages was quantified by reference to compound interest that would have been earned.
Yeah.
And one can see that, I don't seek to take your lordships to it now, but one can see that from paragraph 1 of Sempra. And then it goes on 3 to 5 to deal with the concept of a claim of interest as damages. Now, I don't know whether my learned friend still relies upon it, but I want to make clear that what we're dealing with here is not what my learned friends are talking about in their skeleton. And one goes on in their skeleton in paragraph 11, where they submit that clauses 14.11 and 14.12 give a right to interest as debt or damages, and again we disagree with that. It's interest as an ancillary right, ancillary entitlement to to interest on principal liabilities.
What? I don't understand it. If it arises from a contract, if you have the right to the money as a contractual right, then that is contractually due sum.
Well, can we go to the clauses and I can take your lordship's point?
Forgive me, I don't know what you mean by it arises ancillary.
Well, there has to be an underlying breach in respect to which damages are awarded. And then if there is a late payment under clause 14.11, either party may is the word used, may charge is the other word used, may charge interest at the contractual rate. So there has to be an underlying late payment, but before you get to late payment, there has to be a finding or some acceptance of a liability. It's
Well, I
not,
agree. I mean, it's difficult to understand what the late payment is in the case of damages.
well, it's the date that the court determines on termination money should have been paid.
Yeah.
So on clause, if we can go to the bundle, please, in the contract at page 365. Each party may charge, permissive, simple interest at the rate of 4%, etc. From the due date for such payment till the actual date of payment. And then 14.12, each party agrees that any interest that is payable under clause 14.11 is a substantial remedy for late payment of any sum payable under this agreement for the purposes of section 8.2 of the Late Payment of Commercial Debts Interest Act 1988, and shall be the sole remedy available to the party entitled to interest for late payment, whether in contract, tort, or restitution, or otherwise. So, as I said, it's permissive. It's from a due date of payment, and it's plain in 14.11 that what is being referred to there are invoices. Under 14.12, the application of clause 14.11 is expanded upon, and it refers to late payment of any sum payable under this agreement. And as I've read, it's a substantial remedy for late payment under the 1998 Act. We submit that on a true construction, the entitlement is ancillary to claims for principal sums, as I've indicated, claimed as debt or damages for breach of contract. Secondly, that the interest is not itself damages. It's the sole remedy for late payment of a principal liability. And thirdly, that a party has no right to interest, to charge interest under these clauses, unless two things happen. One, the other party is found liable for breach of contract or duty, and two, there is a late payment in respect of that. That Topalsson understood this is evident from its particulars of claim, where Topalsson actually claimed contractual interest on claims above the cap. And we can see this at paragraph 29 of the particulars of claim at tab 18, page 203 of the bundle. Where, as I've taken your lordships already, we have a claim for 6.4 million, and in the alternative, a claim for the 21611 charges of 3.1 million, page 214, and then over the page at 205, we have reference paragraph 33 to the contractual interest clause, 1411. And then at 13.4, claimant claims interest on such sums as are found to be due at a rate of 4% per annum above the Bank of England base rate, etc. In respect of any element of the claimant's claim to which 1411 does not apply, claimant claims interest pursuant to section 35A of the Senior Courts Act 1981. And then it says this interest on the contractual basis calculated from 9th of June 2020 in respect of the damages claim, as from 16th of April, alternatively 20 April in relation to the alternative claim, and as from the date the payment became due in relation to the debt claim, as set out in Schedule 1. Now, we don't have Schedule 1 in the bundle, but I hope you'll accept from me that the calculation that was provided is a calculation on the 6 million claim at the contractual rate. Of course, nowhere in the particulars of claim does one see any reference to that interest claim being capped. And of course, when one goes to the prayer, one sees a distinction in the normal way between the damages claimed. This is page 207 of the 6.4 million, alternatively 2.2 million, and then lastly, little 6 interest.
So paragraph 34, the claim put by reference to the contract, but to the extent the contract doesn't apply, the claim put under the statute
Yes,
is exactly the same
of
as
course.
paragraph 91 of the amended
Yes,
defence and counterclaim at page 254, which we were shown this morning.
yes. So in our submission, there are 2 good reasons for treating contractual interest as separate and distinct from the principal liability to pay damages or other sums that are due. Firstly, incentive.
Sorry, say again. Firstly,
Incentive. Contractual interest for late payments is a separate and important incentive, as your Lordship remarked this morning, to satisfy an obligation to meet a principal liability, i.e. debt or damages. Secondly, windfall. Where interest accrues in excess of the cap, the wrongdoer receives a windfall. It gets free use of the funds, which it would not have had if it had paid on time. I'm conscious of the time, my Lord, but perhaps your Lordship's note in Rolls-Royce Holdings and Goodrich, which is in the Authorities Bundle, tab 13, page 410, the learned judge quoted Mr. Justice Coleman's judgment in the Athenian Harmony. And he said this: if interest is withheld, the defendant receives a windfall. He has free use of funds, which if he had performed his obligation to pay, would not have been in his hands. That discussion was about statutory interest, but the same holds good in our submission in relation to contractual interest that we have here. Thirdly, we say that where interest accrues below the cap, it contributes to the total liability under clause 20 and effectively reduces the amount of the principal liability that can be recovered at no cost to the wrongdoer. And in our submission, I have an example prepared, but I think it's better to leave it there. Your Lordships get the point that if there is a claim of, say, 4.5 million, then that extra 50,000 for the life of the contract is taken up by interest on my learned friend's construction of the agreement and is not then available for any subsequent claims. As soon as contractual interest hits the cap and takes the amount up to 5 million euros, the wrongdoer who has withheld payment has no incentive to pay it and receives free use of the money. We submit that Topalsson's construction is not consistent with the generally accepted purpose of liability caps. As I've indicated before, the purpose of a liability cap is to manage and allocate the risks to which a company exposes itself when contracting. It's a way of balancing risk and reward. We submit further that Topalsson's construction serves no legitimate commercial purpose. We say that Clause 20 was not designed to provide a mechanism to enable either party to withhold monies due or to obtain free use of that money, and to defeat the contractually agreed sanction for late payment. And nor was it designed and intended as a means by which one party could reduce either party's exposure to principal liabilities, refunds, claims for breach of contract, etc. There's a further point, and that arises out of the wording of clause 14.12, which makes plain that contractual interest is intended as a substantial remedy, is the phrase used, for the purposes of section 8.2 of the Late Payment of Commercial Debts Act. I won't take your lordships to the provision in the White Book, but I'll give you the reference. Under section 6.1 of the Act, interest is at 8% above base. And your lordships will find that in volume 2 of the White Book, paragraph 9b-1345 at page 2737 of that volume. Also in that volume, your lordships will see at page 2738 at paragraph 9b-1349 reference to section 8.2 of the Act, which says that statutory interest under the Act may be ousted or varied. It says, and then I quote, where the parties agree a contractual remedy for late payment of the debt that is a substantial remedy, statutory interest is not carried by the debt unless they agree otherwise. Now, obviously, under clause 14.11, the 4% above Bank of England base rate is a different and less onerous rate than 8% above base. The point has already made, and I endorse and echo, and I'm grateful for the observation that under clause 14.11 and 14.12, the parties intended contractual interest to be a substantial remedy. If it is included in the cap, however, it is not a substantial remedy. A, where the underlying liability is 5 million euros, or B, if the underlying liability is below the 5 million, but contractual interest after a period of time takes the amount to that 5 million cap. So in our submission, at the time when the ancillary right to charge interest on late payment is at its most valuable, i.e. when there is no payment at all and it's being withheld and the cap has been reached for principal liabilities, to find that the parties actually agreed that there should be no interest running thereafter in our submission is wholly contrary to commercial sense and repugnant to the intentions of sensible businessmen. Those are the points that in my submission bear directly on your lordship's interpretation of clause 20. I don't seek to repeat what I've just said, but when one has to construe clause 20 against the other contractual provisions, in our submission as a matter of construction, the language of clause 20 is not apt to include contractual interest. The phrases, we know them, total liability, limited in aggregate for all claims, no matter how arising, are apt to refer to liabilities for damages, debt, for breach of contract, tortious duty, and otherwise. We say they are not apt to refer to the ancillary entitlement of a party to charge interest, if it wishes, in this case, on sums for which a party has been found liable that has not paid. we draw comfort from clause 20.1, which your lordships will find at 370. Where the type of liability that the cap is referring to, but it's not, but it's all of a piece, are parties' liability for death, personal injury, breach of confidentiality, breach of third parties' IP rights. So that's a set of examples. They're obviously not within the cap, but they are of a piece with the liability that clause 20 in our submission is referring to. In short, contractual interest is not included in the cap because it is not a liability, quote unquote, with which clause 20 is concerned. Now, there has been changes over the course of Miller and Friends, the appellant's case as presented, pleaded and presented at trial. But we're now at a position where no statutory interest is said to be payable. If that's right, that serves in our submission to underline the commercial absurdity of the construction that Miller and Friends contend for. If there is a principal liability of 5 million euros and there is no contractual interest and it is a sole remedy and statutory interest is not payable, then we submit that is a very extreme result that could not possibly have been in the contemplation of the parties at the time of contract. I can deal with this very briefly. The whole argument on whether this is debt or damages, whether it's an indemnity, these were not pleaded points. There was a reference to debt in the closing submissions of Miller and Friends, but it was to say, or confined to saying, that 1412 doesn't apply because it only applies to debt and this is damages. That was the way it was put there. So this is, if I have time, I'll come on to these additional points, but I know Miller and Friends are keen to have a reply. As I said, no
can I just on that?
Yes.
Mr. Lavey had all morning, so any time for a reply would be short. So don't feel under time pressure in relation to the points that either the debt damages indemnity point or the and therefore the clause 35A4 point, or the is this point open to them at all?
Indeed, I'm grateful.
So don't feel that you're rushed on those, because they're important points.
My lord, if it's helpful, I was rather working on the assumption that I had 5 minutes and that was that.
That's a safe assumption, and we can't go on too long because I have to call 70 people to the bar a little later this afternoon. So you'll forgive me if that becomes a bit more important a bit later.
May I just make this one short point then? The learned judge awarded damages for repudiatory breach. And that was the case that was argued, that was the case that was accepted. It was accepted by my learned friends, and I'll take your lordships to it in a moment, that this was a claim for damages, and it's simply not open to them now to try and recast it as contractual clauses, as indemnities, and that this is a debt. And there, of course, is no appeal against the finding that the judge made on damages. In reality, if I can just conclude this point on statutory interest for the purposes of construction, Topalsson's construction, the clause 20 limits any ancillary right to interest where the debt or damages claimed is in excess of 5 million, extends both to contractual interest and to statutory interest. So nothing is available. If I can then turn to my learned friends' authorities very briefly, reliance was placed on triple point, clear language is needed, the cap construed, so as to limit the valuable ancillary remedy of contractual interest. I beg your pardon, they're not the learned friends' authorities, they're the authority that the point that we've made before, but we make again in relation to clause 20, if it was intended to deprive either party of the valuable rights under clause 1411 and 1412, we submit that clear words would have to be used. Since it's not just contractual interest, but it's statutory interest as well, according to the learned friends, they fall foul of the Marcus Study and other authorities which say that caps don't include statutory interest. In our skeleton at paragraph 50, we relied on a case called Equitix. We didn't put it in the bundle because there is a further case, more recent case of Irwell, which my learned friend has taken you to, but which we rely upon in support of what I've just submitted. If I can take your lordships to the authorities bundle at page 502.
This is Roger Tahar.
Yes. Your lordships will see that the cap is set out in on page. Sorry, it's 502. Yes, sorry, I've got a bad reference.
Yeah.
Yeah, sorry, I haven't got a bad reference. Yeah, it's 502, and it's a paragraph 390. Consultant's maximum aggregate liability in respect of breach of contract or breach of duty or negligence or otherwise arising out of or in connection with this deed shall be limited in total to 10 million, provided that nothing in this clause 20 shall exclude or limit any liability for the usual things. The passage that we, sorry, I better take you to 459, paragraph, page 459, where the interest provision, no, sorry, it must be,
I mean, the position is there's the clause.
yeah.
He sets out the submissions
He sets out the submissions and it's the
and the submissions that he
adopt.
adopts are those at 393.
393, it's the bottom paragraph 44. More importantly, however, it is clear from the judgment in Equitix on that, whilst the words in respect of a broad of those words taken alone would not be enough to make the claims broad enough to cover the likes of statutory interest and cost. Indeed, the learned judge in that case also found correctly in IRDL's respectful submission that one would confidently expect specific mention of interests and or costs if the parties intended these important rights being foregone. Suffice to say, no such specific mention of interest or cost is to be found here. Part of the purpose of interest and cost is to control and manage the court process, to provide recompense to a party whose lawful entitlement to delay, and to control the cost of proceedings and confer broad discretion on costs. These are very important basic rights, and any parties that have in their contemplation that these rights are being foregone, the case is where the loss is at its highest, hence reaching the cap in the first place, would be expected to say so in terms. And then we have a paragraph 395. In my judgment, IRDL is right on this issue for the reasons given by Ms. Sloan. Neither court interest nor cost are called by the cap. So in our submission, those observations are germane to and compelling in terms of the construction approach that your lordship should take to this clause. I've made the point already that about commercial common sense and rational businessmen. Milena Friend relies upon Fiona Trust, a case that I'm sure your lordships know very well. But the starting position of Lord Hoffman in that case is the assumption that the parties, as rational businessmen, are likely to have intended X. And in my submission, that is again a compelling approach to be adopted to the construction of clause 20 and whether or not it captures interests. That rational businessmen are assumed not to have excluded valuable rights without saying so. And that when it comes to contractual interest as a substantial remedy, replacing their rights under statute, it is very unlikely indeed that rational businessmen would have so intended. Rational businessmen do not generally make agreements whereby late payment of principal liabilities by the other is allowed to go without there being some sanction. Very short point, my learned friend didn't refer to it in oral opening, but there's some attempt in my learned friend's skeleton to equate liquidated damages with interest. They say there's no difference in principle, and they rely upon triple point for that submission. But in fact, the situation in triple point is wholly different. Liquidated damages is a principal liability for delay, for breach. And they cannot be equated in our submission with the entitlement, if the party so desires, to charge interest where there is late payment on a sum that is owing. Perhaps I could, for your lordship's note, invite attention to paragraph 69, sorry, the bottom of page 296 in the bundle, but it's paragraph 69, where Sir Rupert Jackson says, the cap on total liability.
Sorry, which page you on?
I'm so sorry, it's 296 of the bundle, perhaps you ought to.
296 of the core bundle.
Of the authorities bundle. That's my fault.
Yeah.
It starts at paragraph 69, where Lady Arden is saying the issue here is helpfully explained in the following passage from the judgment of Sir Rupert Jackson. And then the bottom of the page, Roman 3, section 2 of Article 12.3 imposes an overall cap on the contractor's total liability. That cap on total liability means what it says. It encompasses damages for defects, damages for delay, and damages for any other breaches. That's the liability. We submit that the clause in our case is concerned. Nothing to do with interest. The learned friend then referred to Marcus' study. I'm not sure taking your lordships to the very, very short judgment is going to elucidate anything more than the learned friend obtained from it this morning. It's very difficult to know in Marcus' study what the reasons were for the conclusion because they're not stated. So my submission, it's not authority for anything without reasons. We don't know in Marcus' study, I think I'm right in saying, what the contractual interest clause said. We don't know whether or not it had an ouster provision for the Debts Act, for example, or whether it said it was a substantial remedy, or whether it said it was the sole liability. And all those submissions in my, all those features in my submission compel one to be very cautious indeed about taking it for authority for any proposition. Obviously, there are different commercial terms. It was obvious, it was common ground in Marcus' study that statutory interest was available in the alternative, not here. And there was no consideration, as far as we can tell in Marcus' study, of the implications of finding that contractual interest was caught by the cap, or indeed, as I've indicated, that contractual interest was expressed as a sole remedy. Those are my submissions on what interest is within the cap. May I deal with the amendment point first of all?
Yeah.
The overarching point is this: the case presented at trial didn't work, it failed. And what's happened now is that the appellant has gone away to think of new ways of putting the case. And the amendments that are sought, we submit, are not just additional arguments on a point of law, that they are different arguments from what was argued below, to the extent it was argued, which failed. And if I could just take you to the draft amendment. I know your lordships have seen it. It's at in page 254 of the supplemental fund. Tab 10. It is itself very tersely expressed. It doesn't really articulate the case at all in relation to interest falling within the cap. Paragraph 1367 above is repeated. It's got the error in it relating to the clause, but that's no matter. And then further, interest cannot be awarded under Section 35 of the Senior Courts Act because there is a contractual right to interest. It's really the first of those clauses which goes to the interest on cap point. I'm not going to address your lordship on procedural irregularity. In our submission, that's a dead duck, and it's not a point that should have been raised. But in relation to whether or not my learned friends should be able to run that now, your lordship has seen from my learned friends' address how it was put as 10 words in a 119-page closing submission, giving us, as I've indicated, one working day, obviously weekends as well, 3 days in which to respond. It was not a case, as I've indicated already, which found any expression in the reply or particulars of claim that went to trial. And indeed, as I've already indicated, my learned friend actually pleaded interest on top of, contractual interest on top of the £6 million claim. So this is a fundamental departure, we submit, from the case that the claimants took to trial, and they shouldn't be allowed simply to go away, have a think about it, and see what other points that they can take. So we do maintain our opposition to the amendment. Your lordship has our authorities in the in our submissions, and of course great caution is required in allowing amendments at this very late stage. We've indicated in our submissions to the court in writing that costs are not an adequate remedy, and as my Lord Justice Coulson said in opening, this is a case where or elicited the observation, this is a case where nothing has been paid against the judgment, and the prospect of getting any money out of the appellants is, we say, vanishingly remote. Obviously, it may depend upon the success or otherwise of litigation in Germany under the insurance policy. But
you accept that this is a pure point of construction and arises on a clause in the contract that we're looking at in any event on the appeal today.
I certainly accept the latter proposition. It is a pure point of construction, so I accept the former as well.
So we're in just as good a position to consider it as the judge.
Yes, but under the discretion that your lordships have, in my submission, that discretion to allow the amendment should not be granted because of the position that they advanced in their pleadings that went to trial, that interest was not caught by the cap. Interest was claimed on top of the cap. And your lordships have seen already the paragraph that I took you to, where it was accepted by my learned friends in their pleading in reply that both claims of the claimant and defendant were capped, but yet in the same, in their particulars of claim, they pleaded contractual interest. Of course, that was a point which they no doubt ran, we would submit, when their claim was for 6 million. They accepted late in the day, I believe in their in their closing written submissions, that the right to terminate for convenience meant that termination was lawful, and that their claim was then compliant to 2611. And at that stage, they had the 10 words that they say allows them to raise this point on appeal. In my submission, you cannot plead one thing and take a case to trial, and then when you come to appeals, decide you've accepted a different position, i.e. that termination for convenience was lawful, that you've got an additional argument. In my submission, that's simply not how this works. And the amount of inconvenience that has been caused is evident from today's hearing, and the endless amounts of, sorry, let me rephrase that without the hyperbole, the significant efforts and costs that have been expended on seeking to deal with the contingent claim that we put in for Section 35A interest. We'd understood that that wasn't in dispute, but apparently it is. The whole of the argument today, the skeleton arguments on the issue of whether or not the contractual interest is within the cap. That's all of the inconvenience that has stemmed from this.
So the point about you say it's more than just not having more than just a point of law which could have been argued then but wasn't is argued now. One of your points is that it is now contrary to what they ran at trial.
They ran at trial up to the point of their closing submissions when they took the decision that they were not going to get over the cap, so it didn't matter.
And
to them.
The same is also true of the 35A4 point, because they pleaded that to the extent that they couldn't have interest under the contract, they could have it under the statute.
Yes.
But they now say the statute doesn't run.
They say the statute doesn't run because of subsection 4, but also the sole liability point.
Yeah.
Well, you adopted the same formula in your defence and counterclaim, didn't you? Which is insofar as it doesn't come within.
Yes.
Yeah.
And none of that had to be unravelled at the trial because effectively there was no dispute about it.
Correct. What happened on the consequentials hearing is that there were a number of new arguments put forward on this point, on these points. Perhaps I can take you, your lordships, to the supplemental bundle behind tab 1. Page 84.
Page reference again, Mr. Charles.
84, ma'am.
Yeah. What is this that I'm looking
This is dealing with our claims for interest.
Oh, so this is their closing submissions.
Sorry, this is their closing submissions. It says we claim interest under the contract. It says it is not so entitled, as noted above, clause 1411 is concerned with interest for late payment of debt, as is apparent from its specification of the interest period. etc. And from its stipulation that interest does not accrue in relation to invoices that are not properly raised or submitted by the supplier. It has no application to Rolls-Royce's damages claim. So their point there on contractual interest was not that it was that it fell within the cap, but it wasn't available to us at all. And then it says this.
I haven't looked at it before, let me just look at it again.
And that's the judge's finding in that regard is not something they've appealed.
And then at 258, if any part of Rolls-Royce's damages claim succeeds in the absence of any evidence from Rolls-Royce of financing rates, there is no basis for interest to be awarded above the usual rate of 1% above the base. Such interest should only be awarded on costs that have already been incurred and not in relation to any later future losses. So we read that as saying that statutory interest is available.
Yeah,
And when one goes to page 63, one sees the section on interest on their claims.
so 1,
63, paragraph 195. Clause 1411, it mirrors roughly what your lordships have just seen. They set out the 4% above base for contractual interest, and they claim it on its debt claim, which is the invoice claim. And then they say, paragraph 196, in relation to its primary damages claim and the alternative claim for contractual compensation, Topalsson seeks statutory interest at the usual rate of 1% above base. So they were asserting that they were entitled to statutory interest. I can find, by the way, there's no reference at all in the pleadings or elsewhere until after judgment of any suggestion that the contractual clauses under 1311 are an indemnity or amount to an indemnity. That again is a new point that's been raised, not pleaded, not addressed, and the substance of it is in any event wrong in my submission, and one only needs to look at the language of indemnity clauses to realise that what we have in 1311 is nothing of the sort. But that's a secondary point. They have no right to raise that point in my submission. My learned friend, Mr. Shirazi, said that because there was no issue about whether or not it was debt or damages or that the judge's reference to damages carries no weight. But firstly, the learned judge dealt with the case on the basis of damages, and she did so because we claimed damages for repudiatory breach. There's no appeal on the finding, as I've indicated, and nor could in my submission there be any appeal.
If you claim damages for repudiatory breach, that must be on the basis that the repudiation has been accepted.
Yes.
And at that point, the contracts come to an end.
The parties are discharged from further performance, yes.
Yeah. And the damages that you then are entitled to are not pursuant to the contract clauses, but they are on the classical basis upon which you calculate damages for repudiatory breach.
My lord, my hope and expectation is that the contractual damages clause survives termination, but perhaps I can just ask my learned friend to check that. I think he's doing it. Yes, it's paragraph 375 of the core bundle. It's the contract at page 375. And the relevant paragraph is 26.6. And of course, says upon expiry or termination of the agreement for any reason, provisions of section 13, charges, payments and expenses continue to have effect.
Yes, I don't think that quite meets the point, though, does it? The fact that those clauses still apply doesn't mean that's the basis upon which you calculate damages for pudictory breach, does it? You may take them into account in working out what you're entitled to,
Yes.
but your damages are straightforwardly the difference between the position if the contract had been performed and the position you're in given that you have accepted a repudiation.
But 1412 is very wide in its ambit, my lord. It's each party agrees that any interest is payable under clause 1410 as a substantial remedy for late payment of any sum payable under this agreement shall be the sole remedy available to the party entitled to interest for late payment, whether in contract, tort or restitution or otherwise. So my submission that would be wide enough to encompass damages for repudiatory breach. My lord, if you just give me a moment just to check.
I appreciate that you say that the argument that statutory interest under 35A is not open to you. I appreciate you say that's new and it's not open to the appellants to run it. Do you want to make any submissions about the cases to which we were referred?
Well, my lord, yes, thank you. I can deal with the debt point very quickly.
Yeah.
This isn't a debt, it was damages. So
Yeah, I understand
that's
that.
not on the table. If there is a discretion, the first task that we have is to get over the sole remedy provision in clause 1412. And your lordship may think that is a uphill task, but in our submission, again, the point of construction at issue is whether or not the sole remedy for the particular things that were set out, contract, tort, or restitution or otherwise, are apt to include and comprehend statutory interest. And by reference to for example, Marcus study, by reference to the case of Irwell that I took your lordship to, we would submit that if the intention was, by the word sole remedy, to exclude statutory interest, a right to statutory interest, then it should have been stated explicitly. Now, I can't put it any higher than that. As I've indicated in my earlier submissions, if statutory interest is not available to either party because of the effect of clause 14.12, it throws into sharp relief the commercial absurdity of Malone Friend's position on liability being within the cap. But if liability is found to be, if contractual interest is found to be within the cap, then in my submission, the construction argument is engaged, and it would be contrary to, it's difficult to say public policy, but it would be an extraordinary state of affairs if no interest was available under statute, where, because of the provisions of 35A4, interest is running. And we submit that the reality is that where no contractual interest is available, either because the principal liability is 5 million euros and the contractual interest is within the cap, it doesn't run at all. If the principal liability is, say, 4 million, or say, let's say 4.5 million, contractual interest runs up to 5 million and then stops, again, we would submit that interest is not running. We would explain that point by reference to the underlying policy of section 35A1 and 4, which is to ensure that parties do not get a double bite at the interest cherry. And there certainly isn't that here, where, if my learned friends are right, the cap is effective to constrain interest, either exclude interest at all or constrain it to sum below 5 million euros.
Yeah.
Right, I think those are my submissions, but may I just have a moment to confirm?
Please do.
with you? Unless there are any questions, those are my submissions.
No, there are no questions. Thank you very much. Mr. Lavey, your 5 minutes starts now.
My lord, I hope I won't need them all. I have 3 short points. The first point is on triple point, where my learned friend says that contractual interest for late payment is different in kind to liquidated damages, and so the reasoning doesn't apply. I say that's not actually so on analysis, because if one thinks about what's the late payment, what an interest provision like this one is, which provides for interest on late payment, it's a pre-agreed rate as compensation for a failure to meet the payment obligation, just like a liquidated damages provision is a pre-agreed sum on breach. So I say actually they are very similar in kind. So that's point 1. Point 2, the impact of interest falling within the cap is not as extreme as my learned friend says. As my Lord Phillips observed earlier, there's nothing to, well, this is not the way my Lord put it, but there's nothing to stop a claim being brought at any stage, and of course interest runs on a judgment debt. The third and final point relates to whether we should be permitted to run the interest point. I'm not going to rehash my submissions, but what would be perhaps useful, my lords, is to draw your lordship's attention to the Notting Hill Authority, which we have in the bundle at page 233. And so this is bundle A, tab 8. So this is Notting Hill and Shake, a decision of this court, and the paragraphs that are relevant to the point are on page 238, where some authorities on new points being taken on appeal are dealt with, and then at paragraphs 26 to 28 at the bottom of the page, there is a sort of summary by, the reason I'm pausing, my lords, I'm just sorry to see whose judgment this is. It's Mr. Justice Snowden's judgment.
Mm-hmm.
And what one sees at paragraph 26, these authorities show there's no general rule a case needs to be exceptional before any point will be allowed on appeal. Then there's the warning of caution, but there's paragraphs 27 and 28. Paragraph 27 explains one end of the spectrum, where basically what the new point does is throw everything into disarray. And paragraph 28 at the other end of the spectrum, pure points of law, which can be run on facts found, and so on and so forth. I say we're at that end of the spectrum. I won't repeat my submissions on it.
Yeah.
My lord, in addition, I believe I have a right to reply on law, but paragraph 11 of the same judgment I would commend your lordship. It's correct that Lord Justice May's judgment in Jones and MBNA, which is referred to there, except it's no longer exceptional, but what Lord Justice May says in that extract is absolute.
Yeah.
the one final point on that, my lord.
And there's also C.
My lord, yes, and CM is cited in paragraph 25
Yeah.
of this judgment, the relevant section. So one can see the principles, and Lord Justices Jackson and Longmore agreed. That's at page 241.
Yeah. In fact, that was all not whether they should do it, but whether the judge below had been right.
My lord, yes. Yes. Those are my submissions, unless I can be of further assistance.
Right, thank you both very much. You'll be unsurprised to learn we will be reserving our judgment. That means that you will get drafts of our judgments. They will be sent to the people on the list which my clerk has prepared, but only them. And so it's not to be sent or shared with anybody else. As you know, there's a huge sensitivity about draft judgments. The draft judgment is an opportunity to correct typographical and grammatical errors. It is not an attempt or an opportunity to re-argue the case. And obviously in this case, I have to emphasize that enough is enough. So
BMW HQ, so.